in that picture. So I can't fight all the tiny battles now.
Okay, so we have everybody now. We are going to start. So we're right on schedule. Thank you very much for being here, all of you. Today we are going to discuss a very controversial topic. It's about the TPP, the Trans-Pacific Partnership Agreement, which has been negotiated in secret for years, in secret for years, and was just signed by 12 countries, including Malaysia, New Zealand, Mexico, Chile, Peru, the United States, of course, amongst some others. And we have our wonderful panelists here that I am going to let present them. We have Carolina Rossini from Public Knowledge. We have Nicholas Bramble from Google. Burcu Kilik from Public Citizen. We have Myra from EFF. Anupam Chander from Google too. Carlos Brito from R3D. Sorry, I presented you as Google, probably not. Carlos Brito from R3D, Juan Carlos Lara from Derechos Digitales, and Pranesh Pakar. So we are going to start. We have a lot of panelists, so I do ask you to make your interventions short and poignant, please. And let's start with, what was my order here? My notes. Okay, let's start with Myra. So Myra, we're wondering, being from the EFF, what is the position of EFF and yours regarding the TPP in the digital rights realm?
So once the text finally was finalized and it came out last fall, we were able to definitively say that we were against the whole thing. For up until, I guess, last fall, we'd always said, well, if these provisions do not contain copyright term extensions, for instance, a weak obligation from countries to have balance in their copyright rules, and also DRM, the ban on DRM circumvention, those sort of things, we sort of had red lines at the EFF about the digital policy provisions that we did not want to see in the TPP, and if it would end up in there, we would be against it. And we saw almost everything that we had been talking about for over 5 years in the TPP, so we are against it now, and our activism is involving fighting its ratification in the United States and around the world.
Perfect. Let me just ask one question to the audience. Does everybody know what the TPP is? Can you raise your hand if you do? Okay, perfect. Yeah, it's just, it's just such a complicated topic that we were wondering if we should start by explaining the whole TPP or getting right into the discussion, so I'm glad. Exactly.
6,000 pages? 6,000 pages?
Exactly.
We should do an overview.
Yeah, so Carolina, can you tell us a little bit more, like a broader spectrum and scope of the TPP, so then we are all on the same basis and we can start right off with the controversial points?
Sure, and I'm gonna try to be fast and quick to explain 20 years of U.S. trade policy. But to simplify that, what happens is a lot of times when governments cannot pass bills inside their countries, they go shop that around, but that's not also a reason for trade agreements, is where we want to diminish trade barriers that create barriers to trade. But nowadays, the trade barriers have expanded in such a way in terms of what U.S. consider trade barriers, that those nowadays include exceptions and limitations on copyright. So if you are advocate for access to knowledge, you should pay attention to that. It includes strong privacy rules. In the hearings where the safe harbor was challenged, after the safe harbor in Europe was canceled, annulled, in U.S. companies wanted U.S. to challenge Europe at WTO, the World Trade Organization. That appeared and is recorded in one of the hearings hearings in the House of Representatives. So, and nowadays, then strong privacy rules are considered a trade barrier. So you can check that that's all documented in documents that do this. So trade agreements have expanded a lot over the past years, from bilaterals to multilateral trade agreements outside the realm of the World Trade Organization, exactly because there the geopolitical power is one-to-one. So South Africa or Brazil or Malaysia has the same vote as developed countries. And then you go to other areas where the trade-offs are harder. So what we heard from Peruvian debaters is that we need access to our commodity, to coal and mineral markets, and that's why we are not fighting so hard for some exceptions and limitations provision in trade agreements. So the trade-off is much harder, and then we win less in that realm because the trade-offs are more immediate commerce interests, which is legitimate, but then at what cost, right? So TPP came into place, was negotiated over almost 5 years with almost 11 rounds or so. Bourgeois is one of them here that 30, yeah. Bourgeois has been in all the rounds. Bourgeois. Yeah. But anyway, independently of the, and we were under, we were in the corridors talking to the negotiators and using 2 minutes to speak in the stakeholder meetings to really try to impact somehow the text pro-digital rights, pro-privacy, pro-access to knowledge, with less weight on ISPs to police content, but also to have access to spectrum and so on. A series of chapters matter to us, and I'm sure my colleagues will cover them. Here, I think the telco chapter is an important one, the e-commerce chapter, the intellectual property chapter, the general chapter, those are all relevant, and they mean different things from different countries. So don't take what we say as the final word, and do check the chilling effects in your country. While the telco chapter is a great chapter for US, is everything that civil society in US wanted, it might be a horrible chapter for Malaysia because the incumbents here are the entrants in Malaysia. So I just want to be sure that we have all these facets in mind when reading the 6,000 pages.
For sure, right.
Okay. Just to summarize and add on to what Carol said, like the idea behind trade agreements is it's, at the end of the day it's trade agreement, and there is always something for you on the table. So what the US and other developed countries, including the EU, do is, like, you know, they say that, like, okay, you will have a better access to our market, but in exchange of that you have to you have to have those rules, and those rules are good for my industry and my innovation, but, you know, you will have a better access to my market. So, and for the countries, it's like, it is a good deal, because either you are part of the club or not. Now, that's what's happening with the TPP, because we know that TPP has 30 chapters, 6,000 pages, and no one read, I think, all those chapters. And there is always something for you in those chapters, but it depends how much you want to sacrifice or compromise. But at the policy level, at the policymakers level, at the end of the day, trade negotiators are negotiating this agreement, and trade always comes first, not the digital rights, not the access to medicines, or not the ISP liability. It's always the trade. And when they signed the agreement, like in Atlanta, like, they finalized all the chapters and they did the market access negotiations at last minute, you know, because that was the priority for the US. US said that, okay, we will finalize those chapters and then I'll give you the market offers. So that's how the trade works.
Well, thank you. I just wanted to say to the audience that on Slido.com, if you use the hashtag RightsCon and choose the bridge, we get all your questions on the screen, and there's like a cool mechanism for voting. So that's also a good way of engaging in discussion and not forgetting your questions as we go. So I really encourage you to use that. It's a wonderful tool. So why don't we go to Nicholas, so we maybe get another perspective on the TPP. I wanted to specifically ask you, there's been a lot of debate around intermediary liability in the provisions of the TPP. Some say that it's exporting DMCA all over the world without without the safeguards and the DMCA has. So what is your take on that? And we saw recently also communicate from the Internet Association regarding the TPP. So I wanted to ask you about that too, being that Google is part of the Internet Association.
Sure, thanks, and thanks for organizing this panel. I have laryngitis, so I'll try to keep my remarks kind of brief. On intermediary liability in trade, sorry for my voice cracking. So you're right that a lot of the TPP language does mirror a language from the Digital Millennium Copyright Act, Section 512 from the U.S., which is a balance that was struck in the U.S. about 20 years ago now, 15, 20 years ago. Is now actually being debated again in the U.S. There's been a comment period that closed, I think, last night, where people were trying to figure out ways to actually undermine some of the protections of the DMCA that has struck a pretty good balance over time. Anyway, should this be the model for notice and takedown regimes around the world? I think that's an open question. I think there are other models out there that are actually quite effective. So the Chilean system of a digital notice can be quite effective. There's a Canadian notice and notice model, which is also has proven to be sort of just as efficient in getting sort of bad content, illegal content removed, but has been a sort of more user-friendly kind of implementation of those rules. Now, fortunately, I think the TPP does allow some flexibility for countries to adopt Chilean style or other sort of administrative style rules. Unfortunately, I think the Canadian model is relatively closed off. I think that actually goes to a sort of a point maybe about how it's important for our community, civil society community, I'm not counting Google as part of civil society, to be really engaged and actually really pushing forward positive frameworks for countries that are negotiating trade agreements. So, for a long time, trade agreements were left to industry insiders who don't, necessarily reflect the interest of 3 billion internet users out there. I think there's a real opportunity here, and there are lots of consultations going on now as the TPP is being debated in countries. And there's an opportunity, I think, for people to put forward some more positive frameworks around what they think trade could accomplish, what trade means in the digital era. And just to be clear, trade has changed significantly thanks to the rise of the internet. There's a study recently that said that data flows now account for more global GDP growth than the flow of goods. So this is a really serious change happening in what we think of as sort of what trade means, and I think everyone should sort of seize this opportunity to come up with new models, new visions, new frameworks for what trade can accomplish. And one way to actually do that work is by finding TPP implementation processes around the world that are happening right now. New Zealand ran a public consultation on its sort of TPP IP implementation rules. And that, unfortunately, it closed last night, so anybody who wanted to contribute, sorry about that. But hopefully some folks here have contributed. I think EFF was filing comments. Google did as well. And there are ways to use provisions in the TPP to push for things like fair use, for more user-friendly intermediary liability protections. And this is again just a chance for everybody here to seize, I think, to sort of redefine and reclaim trade for the digital age.
Thank you very much. Did you want to say something?
I sort of wanted to say something to that, which was, I just wanted to address one point from the Internet Association statement from 2 days ago endorsing the TPP, in which it just actually contained a blatant lie, which was that balance in copyright is required, and that's exactly one of the major points in which all of our civil society groups are sort of horrified by, was this simply like 3 words that changed obligations from countries having balance in their copyright to just merely seeking balance in their copyright rules. And it was just a huge disappointment to see that in the statement. And I know you don't speak for the Internet Association, but when last summer there was sort of a scramble when I think many of the tech companies realized that this language sort of was on the table and it was being discussed, they sort of went in, it seemed, at the very last minute to try and get this from the U.S. Trade Representative to propose this to other countries. But last summer was just way too late. I mean, if they had done this maybe 5 years ago or even 2 years ago, then maybe it could have actually been put in there and required countries to have balance in their copyright rules. But it was already very late in the game. Everything was sort of a trade-off between car markets and medicines, and so it was very tight. So, I think over the last 4.5 years I've been working on TPP activism, the sort of major shift that I saw was how many of the major tech companies were either, anti-TPP, I mean, not blatantly, or sort of just sort of cold to it. And I feel like that shift really changed when the issue of these cross-border data flows were really on the table, and they saw a lot of economic benefit from that.
Okay, perfect. Yeah. Make it short so we can.
Sorry, just one quick response on the balanced IP language. So I'm just going to read it. Sorry about that. Each party shall endeavor to achieve an appropriate balance in its copyright system, among other things, by means of limitations or exceptions, including those for the digital environment, giving due consideration to criticism, comment, news reporting, teaching, scholarship, research, and other purposes. Now, I don't think you can say that that doesn't require the adoption of. No, but let's actually read the language.
Okay, let me pause you there. We're going to go all the way, and we're coming back to that
Also,
point.
by the way, I mean, if that's your message that you're delivering to New Zealand, that's not actually.
Hey, we are discussing that point, but we're going round. Hold it. And I really want to get the Latin American perspective on this before we go round, and because I think we all should discuss that part of the text. It's a very controversial one. So let me ask Juan Carlos first. How do you see the TPP from Latin America? What are the greatest dangers? How is it different? And regarding digital rights, what are the greatest concerns in the region?
In terms of digital rights, our concerns have been pretty much the same that we have shared with other organizations like the Electronic Frontier Foundation in the past, and that we have also managed to get the negotiators to address in a way. In many ways, the TPP is not as bad in the end as it was in the beginning for many of the things that we were concerned about, and that has to do in many ways with how civil society has worked with negotiators and the advocacy that has been happening. Of course, it does not mean that it's a good agreement in any way, but many of the provisions were quite worse than they are right now. For instance, in intermediary liability provisions, they could have been much worse, but that's not the point. There are other concerns about the locking in very long copyright terms, for instance. There are bad provisions on technical protection measures and the sanctions against their circumvention, which are pretty bad themselves, which in many ways follow what other trade agreements had in the past, but they lock in a system that is very dangerous. But the big problem is not necessarily that the provisions are bad, but the idea that we are making our internet policy through trade agreements, instead of deciding internally each country how they want to develop their own strategy for intellectual property, how they want to provide incentives to innovation, or how they want to protect intellectual property itself, or to balance it with the rights of users, either as creators, as consumers, as citizens, when they want to get involved in a larger conversation with their own societies. So it's a dangerous precedent in that sense, because even though we might say that, even if we could have said that it struck some sort of balance, and I'm not saying it, it's just not, it's still a dangerous precedent about how we are trying to develop copyright or internet policy in general, which is a very bad thing for countries, for developing countries, especially in the global south, that see how their development models are being framed and are being shaped not by their own intentions, not by the self-determinations of their people, but by trade policy.
Definitely. So what you're saying is there's kind of a mislink between democracy and this negotiation of trade agreements, something that has definitely been put in question. Taking this into consideration, Carlos from Mexico, what are the greatest concerns being that Mexico is an authoritarian, the perfect dictatorship country, as Nobel Prize Vargas Llosa called it, what are the main concerns of the TPP being implemented in Mexico at this time?
And well, you said it. That's another problem. That's part of the discussion, that there is an agreement that ends up so many discussions of what will be better. We are having so many discussions, for example, on neutrality, on what to do with intellectual property, what to do with so many things. And it seems like it's a final word in so many points. It's not just like, okay, you may it's so funny we have this discussion. It's so funny we have academics. It's so funny. It's cool, but this is it. This is a choice we should go. This is the path we should go, and there are so aggressive ways to enforce that. And the problem is that it's also, as you said, Mexico is dealing through human rights crisis. We have more and more evidence each day is an authoritarian regime, and that's a problem again, because it happens that we assume from the U.S. probably, or from Canada, from New Zealand, from Japan, that when you're dealing with Bahrain, for example, or with Mexico, with probably Peru, with such weak institutions, with such weak democracy, with so much levels of corruption, of media concentration, with all those problems, the discussion has to take that into account, because we are dealing with human rights. And the problem is that the usual way, when you have a human rights interference, or the way the NGOs are dealing in Mexico, at least, is through constitutional litigation, all that, is that they ask questions to themselves, like, is it necessary, is it proportional, is it legal, all this stuff, for example. And the problem is that having this, as Carolina said, this way that the state circumvented all that, the democracy itself, and when, no, this is going to be the way, well, it like kind of handcuff the civil society in so many ways. So what we're dealing now is where we're building a coalition, because you need to know this, there is no public discussion at all in Mexico of TPP. We do very few, to be honest. We're very few who are even interested in this. You don't have this discussion, not even in the red circle, in the columns and the editorials. They don't talk about that. There is no public discussion. When you say they're debating this in other countries, well, not in Mexico. That's the case. And you know why? Maybe a reason is because we are having so much other problems. We have disappearance, journalists killed, so much poverty and inequality and women's feminicides. So that's a problem again. How can you expect a trade agreement like that with such interferences with human rights not being, and not actually maybe at some point increase disparities and these asymmetries between countries?
Definitely. Thank you very much for that. So Anupam, what do you have to say on that?
So I just want to pick up on what Carlos said. The rise of authoritarianism around the world, even in the United States, you could worry about this issue. So I'd like to talk about two generations of internet border controls. The first was, of course, censorship, right? So we want to stop stuff from coming into this country. Think of the Great Firewall of China. We'll keep information that we don't want from coming into this country. I think today we're seeing the rise of a second generation of internet border controls, which is to stop information from flowing out of the country. And that information would be stuff like complaints about local conditions, information that dissidents might want to share. Why would you want to stop this information from flowing out? Well, maybe to stop other people from hearing about it, but also so that you can make sure that the information about dissidents is held locally, so that you can order the local authorities to round up the usual suspects. You can actually identify them with great precision. So I like to talk about this as a kind of simple formula. Censorship plus data localization equals total control, right? So you have the possibility of creating a really totalitarian system by controlling what information comes into the country, but also controlling and identifying all the people who are thinking, have the inkling of doing dissident activity. How do you know this? look at their searches? How do you know who might be involved, with this kind of nefarious activity as you see it from an authoritarian perspective? Well, you follow the links of people who liked that activity. So this is the concern that I think is a very serious concern for companies and countries across the world. And so this is part of, I think, very much the background, the backdrop to Apple v. FBI. What is Apple's view of serving as the spies for a local government? Well, Apple is resistant to these things, and we've seen a lot of tech companies being resistant to these in as much as the legal process might allow in those countries. So where does trade come into this? So I've talked a lot about this kind of basic idea of data localization leading to the ability to exercise greater authoritarian control over your local population. One of the things that trade does is that it says that you can't discriminate against foreign providers. That's a basic premise of trade law. So in goods, we saw this over a century. You can't say, I'm not going to accept goods from some other country because that stuff is dangerous. Okay? You can show that it's dangerous. You can say it is actually dangerous, and therefore you can prohibit it. That's fine. But you can't simply, I'm sorry?
Brazilian meeting US.
Yeah. So you can actually say this doesn't qualify under our local rules for safety. That's all fine. But those rules can't be designed in a way to pinpoint the foreign product and keep it outside. They have to actually have some basis of promoting consumer safety and protection. And so this is what this new round, so the TPP has 6,000 pages, as we've heard. It's full of good stuff and bad stuff, stuff that you would like and stuff that you would not like. So I think it's a little bit of a complicated question as to what we should all think of the TPP. We should, I think most of us, embrace the fact that it allows for more goods to flow from states like Vietnam into the United States, with lower tariffs, right? That is a good thing, I think. And it's a good thing when we say to Vietnam as well, hey, your requirements that stuff be held within Vietnam with a local Vietnamese person present so that you can make sure to be able to put him in jail or her in jail, that's not permissible. And so I think there's some really good things in the TPP about that aspect of it. So it's hard to defend the TPP as a whole. I haven't read it, the entire thing, but I think there are some good aspects of this, which I think many in our community have been debating, and I think there's a great debate to be had about the value of this in general. Thanks.
Thank you very much. Definite, very good point about trade and goods and bads about the trade part. So I see that Pranesh posted a very interesting link that I wish we could open. So I want to ask you, Pranesh, what are your thoughts on IP royalties regarding the TPP? Why did you suggest this link?
So that particular link goes, I think, to speak to the question of trade and IP and who it actually benefits. So sure, in trade there's always the potential of good. One example of trade that I don't think is necessarily good, even though it encourages greater openness, is, for instance, there are books that are published in India designed for the Indian market, meaning being sold at lower prices that are affordable for Indians. Now, I've been making the argument in India that we ought to be able to import books freely from other countries for various reasons without the permission of the copyright holder. So the latest editions of some books aren't available in India, aren't being sold as Indian editions, and we ought to be able to import them. But now in the US, if the US copyright law says that regardless of where it's published, even if it's published in India for the Indian local market, we can import it, then that actually doesn't help Indians, right? That actually leads to the books being printed in India but flowing out of India immediately. Now, that creates a problem, and that particular map I think is a larger statement about trade agreements and IP, where what developing countries are told essentially is, bring your laws on patents, copyright, trademark, and geographical indications, and all other forms of what are designated intellectual property, quote unquote, bring them up to a certain level, and in return, you'll get technology transfer. In return, you'll get this host of benefits. Has that actually happened? No, it hasn't at all happened. And that's... They are abolishing technology. Yeah, and that's part of the problem. So if you read the language of TRIPS, if you read some of the preambulatory kind of language, it's actually not bad at all. It's actually surprisingly not bad. But if you look at the effect, it's not been positive. It's actually been negative. And while the imports, so while IP royalty that India earns is increasing, it has been increasing, the amount of IP royalties that India sends out has been increasing at a much larger pace. And if we could only open that link, you'd see that essentially the whole world is the US. Okay, so all of 54 countries of Africa are a tiny sliver on that map. There, it's hard to even notice it, right? So it's a really dire situation. But that's not what I wanted to speak about. I wanted to quickly say a little bit about the provisions on intermediary liability. And over the last 1.5 years, I've been involved in a project called the Manila Principles on Intermediary Liability, which deal with the issue of intermediary liability, but also content removal. And that was a set of principles now endorsed by, I believe, 95 organizations, and which was mostly civil society actors coming together to say, this is what the provisions, an ideal set of provisions on intermediary liability, on content removal, on due process requirements, on transparency and accountability would look like. And if I could, do I have 3 more minutes to just speak a little? If I do, then I'll continue. Otherwise, I'll take another turn.
Stop you there.
Okay.
It's a lot of topics, but that is definitely something that we're going back to, intermediary liability Manila Principles.
Okay, then I'll just in one
Perfect.
line summarize it and later get into it, which
Definitely.
is there are some good things in the TPP on intermediary liability, but the majority of it isn't, and that's a bit that's of concern.
Yeah, we're getting to that. So I have an intervention from Carolina and from Burshu. I would also like to put the health subject on the table. I know it's like a digital rights panel, but the health provisions of the TPP regarding intellectual property are one of the most scandalous. So just put it on the table and leave it there. So we have Carolina. Let's do Burshu. And if you want to come back to the discussion that you were having earlier, that could also be good. And then we can do another set of rounds and responses. We have a lot of questions, very good questions too. So let's try to keep it short so we can have enough time to discuss and engage with the public as well.
So I'm gonna just make a pledge under the risk of having some of my friends attack me later. My pledge is, now we have a strategic challenge on our hands, okay? TPP was approved. We may not like a lot of things that are on it, but we all, as lawyers, we understand that a lot of it will depend on local interpretation and implementation. So we have a responsibility as civil society organizations, advocates, academics, and companies to speak to our representatives and say, this is the way that this should be implemented. For the first time in a trade agreement, it asks for multi-stakeholder consultation, whatever you understand that has is, and whatever good or bad that it is, but it opens a door. So my pledge is, let's try to implement the horrible 3-steps test language that's there, has the best interpretation we can pro access to knowledge. Let's try to see the spectrum provisions, the DNS provisions, and all the other provisions that impact on every layer of internet as best as possible. And then we're going to have to go back and walk the walk of the Congress and do that. And at the end here, it depends on what society and what knowledge society we want, because at the end of the day, countries have done very strong commitments at the WSIS level, at the OECD level, and we need to ensure and make them at the Sustainable Development Goals level, sure that trade agreements are interpreted based on those principles that are broader and bigger than trade agreements in terms of a political commitment. So I think this is my pledge for all of us, and well, I think this is and in terms of the society we want, I think the map that Pranesh brought is very important, because this is also asked from us during this interpretation and implementation of TPP, what is the type of society we want? Because it's true that nowadays the internet economy is more important in terms of development and growth than the commodities economy. So if the doors are being closed for internet innovation, for generative innovation, for permissionless innovation, we need to make sure that our representatives understand those risks and implement TPP through legislation that actually keep the internet open. So it's our responsibility now.
Okay, thanks, Carol. No, that was very motivational, but I have to break the news, and I will be the devil's advocate here, and I see a question here. Is that true that they will force countries to change local law, pass a test, and only then be able to ratify the TPP? Yes, because there's a certification process. So it's not that we signed this agreement and we'll implement as the way we like. No, it's not going to happen. I'm so sorry, because the U.S. Congress has to certify countries' laws that they implemented in a way that the countries, the USTR approves. And I see some Australian colleagues in the audience, and you can ask them their experiences with the implementation of Australia FTA, because when Australia was implementing the Australian FTA, the copyright provisions, they drafted the law, they sent it to USTR, and USTR sent them back, and they said, like, no, that's not what we agreed. So you have to improve this provision, and that's going to happen with all the countries, like in the TPP. So it's important to be there during the implementation process, but we don't have the freedom and we don't have the independence. At the end of the day, it would be USTR and the US Congress which will say yes or no. So, and you need to pass the certification to receive the trade benefits. So we come to the same question. It's all about trade. If you want to receive the trade benefits, you have to implement the TPP as the way they like. So that makes the TPP more controversial when there are like all these ambiguous provisions. Like ambiguity doesn't help us, because we know that it will come back to us during the implementation phase. And I want to comment on that cross-border data transfer issue. Yes, that's one of the innovations of the TPP. And the Chapter 14 e-commerce chapter includes a provision on cross-border data transfers. And yeah, it is the reality of doing digital business, like internet-related business in this century. But also, like, with that provision, now the privacy data protection becomes like a trade exception, because the very existence of privacy is a non-tariff barrier. And check the USTRs, like the non-tariff barrier, like the list of non-tariff barriers in Europe, in other countries, and they consider as privacy rules as a non-tariff barrier. So for countries now, in order to have like privacy systems or privacy rules or let's speak with the trade language, legitimate public policy measures, we don't even know whether privacy is a legitimate public policy measure, because according to WTO rules, it should be widely practiced measures. And when there's a country with the US, like the US, which doesn't have like a blanket privacy protection, like it's really hard to claim that it's a widely practiced like policy measure. So it has to pass that test to be justified by the countries. And the worst thing is like that language comes from GATS, General Agreement in Trade and Services, which also comes from the General Agreement from in tariffs. like from 1940 is that exception language in the TPP. And in last 20 years, there were like 44 cases where countries tried to use that exception language to justify the other public policy measure related to, you know, like the food, environment, energy. And there were 44 cases, and it failed 43 times. So it's like now we have that challenge. You know, we talk about privacy, but at the end of the day, when you look at the TPP, privacy is a trade exception, and we don't know whether privacy will be considered legitimate public policy measure and will pass that text. So it is quite like controversial. It's ambiguous, but like in trade war, ambiguity doesn't help us.
Definitely. So we're going to do Anupam, Carlos, Juan Carlos, Pranesh, because now I really want to know about intermediary, your criticism to the intermediary liability in the TPP. And Myra, I think there's a question that if you want to address, the third one, is the list of non-compliance measures a way to save national policies from the scope of the TPP? So let's do that. Make it short, please.
Sure. So quickly, with respect to the question of whether or not that the data flows provision eviscerates local privacy law, I think, in fact, it doesn't. The data flows provision directly talks about data protection regimes across the TPP member countries that it encourages, that it doesn't specify what they should be, but it expects that each country will have them. So it recognizes clearly the fact that data protection as a legitimate public policy interest. The question that it asks is whether or not those rules that are in place are in fact designed to be to make foreign provision of services more onerous, more difficult to provide than are legitimate to defend that public policy interest, a legitimate interest in data protection. So, Birju talked about prior GATT and GATS case law. The only GATT and GATS case law related to the internet has largely been very much about pro-liberty, actually. So think about these cases. There's the Antigua claim against the United States, which tiny island nation, you know, I come from UC Davis, University of California, Davis. The nation is the size of Davis in terms of its population. And that doesn't include the student population. That's just the, you know. So the tiny island nation successfully brought a claim against U.S. online gambling law, which said basically that the U.S. claimed a public policy exception. It said, hey, look, you know, because of morals, because of underage gambling, all these other issues, we think that we should keep online gambling, make it illegal. The WTO appellate body accepted that. They said, sure, that makes sense. If you have, you know, you against underage gambling, you have all these other, you know, you're worried about fraud, et cetera, you can keep it out. But you have this odd thing where you allow for online gambling on horses. Yeah, so how can you possibly square that and say, well, you can't provide? So it caught the United States in its own petard, right? And so that's what trade law is about. It doesn't say, hey, look, you can't have, you know, rules against, you know, children gambling or fraud, et cetera. It tries to say these rules are designed to be protectionist as opposed to being open to allow trade across the world. There's a lot of trade law that I don't like. So I'm not trying to defend all of trade and the trade law. And Pranesh has raised some very important issues, et cetera, and everyone here has raised really important issues. Myra has raised some really important issues. I think on this one aspect, I think we should feel as, you know, internet rights community that we want data to flow across borders, that, you know, that's Article 19. Regardless of frontiers, that's the goal of international human rights law, and certainly the way to promote both economic and human liberties. Thanks.
Juan Carlos, and then Pranesh.
Yeah, another part on the effects of the TPP and freedom of expression. There's one that concerns Mexicans, I think. The most, and may not concern some other places as much, but they do. In every net neutrality discussion we have, we are discussing blocking, throttling, tiering. We are discussing zero rating. We are discussing so many things, and there are good discussions on that. There will be some advancement on that. But on the electronic commerce chapter, there is a provision that has this terrible language, very fishy.
Yeah, it's net neutrality without saying the N-word.
Yeah, you don't say the N-word.
Don't say the N-word.
Don't say the N-word.
It's open internet without the N-word.
And it happens the same with climate change. You don't say the C word as well. They don't say the N-word. It's not net neutrality, but it's kind of there.
Open internet.
And open. So it says, it's actually Article 14.10. I always go with that because there's many people that don't even know that there is some net neutrality issues there. But the main problem is that we're discussing here and everywhere else all those problems those practices against net neutrality, and we don't discuss one that is exactly in the footnote number 7, that is the exclusive content for ISPs. The fact that it says entirely the ISPs will have the ability to have exclusive content, and that won't be interpreted as a violation of the neutrality principle. But it doesn't say the N-word. So that's a big problem. That's a big problem that ISPs have exclusive content. When you combine practices, some kinds of zero-rated, for example, plus exclusive content, then you might have a bigger problem. And I don't know if Internet Association have taken that into account when they say, yes, me. That's legacy. And actually, I pointed out one of the negotiators of the U.S. I came and actually asked him that. You are bragging about this huge picture in neutrality and on the FCC rules and all that, and then you come with this in the shadows. It doesn't seem like a bit contradictory for you. And he was outraged because he actually said that my civil society haven't come with this problem. So I won't say anything. But the problem is that for countries where you have such extreme concentration, I cannot say it anymore, extreme concentration of telecommunication services, extreme concentration of broadcasting services, extreme concentration of printed media, you have a problem as well, because having those kind of policies for ISPs and the application market may have really, really bad effects for especially our countries. I would say Chile, Peru, and Mexico share that in common. Yeah. And that may not be a problem for some other places. Definitely. Not that problem. But yeah, so I will, that's a footnote. That's a footnote. And so I will encourage you, whenever you go and talk with the neutrality panel, also include the exclusive content issue as part of this, because it's a way of the discussion in every sense.
So I see Juan Carlos getting excited.
Yeah, it's always exciting to hear people from Latin America react to the provisions of the TPP and how they actually get to impact their own countries. Because that's one of the problems that we see, that in many of our countries, many of the problems will not be addressed by the TPP, but might be actually heightened by the TPP, or the countries locked in away from possibly addressing them and possibly changing them, because now we are trapped under TPP provisions and we cannot change internal law. But this is one side of the TPP that we have seen as problematic, that the language of protections, for instance, in intellectual property, in a way that is balanced, or in a way that is actually beneficial to the people, it's still subject to the process of certification. So there is one point that Carolina mentioned that we can agree on, that we might try as activists, as lawyers and everything, to do as much as we can to actually help a good implementation. But we're not at that stage yet. There's still something to say by the Congress of the countries, the TPP countries that have Congresses, because not all of them have a national Congress to approve the treaty. But there are stages to go through that at some point do involve the community and do involve our work to say, whether this should or should not be signed before we get to the implementation. So there is still room, even for each country, to democratically say no. So there is still room for that. And eventually we'll get to the implementation, maybe. And there's lots of work to be done there. There is the problem of fighting certification, or just struggling with the fact that USTR decidedly opposes some of the implementation processes that have already happened. I mean, according to the USTR, even the Chilean intermediary liability provisions are not necessarily implementing correctly the free trade agreement between the two countries.
You didn't have certification.
What?
You didn't have certification.
So we were so lucky. So we will be subject to certification now. So that's still a struggle. But let's go step by step. We have opposed the TPP in the past. We have tried to influence negotiators in the text. But there's still a process of democratic approval or rejection of the TPP, and we still have lots of work to do on that. And we still are putting our money in as much as we can and our efforts towards a broad discussion on that.
Which civil society money?
Our own, obviously. No one's funding this, but we're still putting our efforts into it.
Okay.
But we do what we can, so that's always a struggle, but we're still in it. The treaty has been signed, but we're still in the process of approval, implementation, and everything, and we still have work to do there.
I like that you're saying that, because you're just addressed the second question that we have here. What can be done now to stop the TPP in your own country? Is there any probability to kill the TPP at a national level?
It's something like, because even in the US, we don't know whether it will pass the US Congress. You know, Internet Association endorsed the TPP, but I don't think that is enough. Like, you know, because there are many industries and many congressmen who are not happy with the TPP, and so we are not sure whether the TPP will pass the U.S. Congress. So we might kill it here, maybe, right?
There's hope. Okay, so let's do Pranesh, and then we go to Myra.
Just one general comment first, which is, even as late as 2005, when the development agenda was being discussed at the World Intellectual Property Organization, which is a UN body. Even at that time, the Indian representative there was talking about the damage that TRIPS has wrought on developing countries as recently as 2005. But now, everyone looks back to the golden days of TRIPS and how wonderful it was and how wonderful it is, and because we're just progressing in the wrong direction, and things are getting so much infinitely worse in terms of the in terms of the balance between developed and developing countries, that now we want the bad agreements that we opposed even 10 years ago. On the issue of intermediary liability, well, firstly, all of you should go to manilaprinciples.org and just take a look at this document we inaugurated last RightsCon, actually around exactly a year ago at Manila. It's pretty short document, 6 broad principles, and some of which the TPP actually does provide for. So, in the annex, which is where this is discussed, it says there should be no requirement of proactive monitoring by intermediaries. So that's a very positive provision, that there is no strict liability for third-party action. So knowledge can be used as a requirement. It also requires penalties for bad faith takedown requests. So all of that is positive. But it does not require court orders the way that the Manila Principles requires, except the 2 exceptions are Chile and Canada, which were grandfathered in. The due process requirements are weak. Notice and notice system is what we recommend, though not require, as part of the Manila Principles. And the TPP does not provide a right to be heard. So your content can be removed without you having been given a chance to defend that content as, say, falling in the US under fair use, or in India under any of the specific exceptions. We have more than 26 exceptions. So you're not even provided a chance. And let's remember, this isn't the question of, say, something like child pornography or something for which there aren't very many exceptions. This is inherently, anything that is copyrighted can inherently be fairly used. There are exceptions where you can make use of copyrighted material. So in those kinds of situations, not being given a right to be heard is particularly grave. And just a second. Sorry. The Manila Principles have really good provisions on necessity and proportionality, which the TPP entirely lacks. There's no requirement of specificity of content. In India, I've written about this, about how way too like entire websites and web services. Google Docs was blocked in India for a bit because of copyright complaints. Pastebin, which is a text pasting website, was blocked because of complaints by an entertainment company. And Pastebin doesn't even host video, right? So all kinds of blocking has happened, and that is not prohibited by TPP. The kinds of, for instance, here in the US, the entire websites, their DNS, their domain names have been revoked because they had .com or .org or .net addresses, and without having been given a right to be heard through the other party, and that is completely legitimate under the TPP. So that becomes a problem. And I'll just end by saying that the TPP, there's a provision in the Manila Principles on transparency and accountability, which, amongst other things, seeks to restrict extrajudicial measures being used, whereas the TPP actually encourages extrajudicial measures, which it calls voluntary practices in terms of incentives to be taken. Now, I can understand those who believe in that nudging can be good public policy, but there should definitely be greater public discussion about this. And unfortunately, that's what the TPP has not encouraged. So, sure, there are a few good provisions, but they don't comply with what a large number of civil society actors have set as the ideal high watermark for intermediary liability.
Thank you very much, Pranesh. So I'm going to make a little pause because the public is claiming. Can Google please answer the question on their position on the Internet Association TPP statement? Reddit, another association member, has rejected it. Sorry to put you on the spot, Nick.
I will answer the question. Although, of course, I don't speak for the Internet Association, and I can't speak to the balancing they did in deciding whether or not to issue a statement in support of congressional action on TPP. As Google, we have not yet taken a position, and the reason why, I think, is we're still exploring and trying to understand the implications for implementation at the country level. That's, I think, really critical to any analysis of TPP.
Will Google release a statement saying that you're still making up your mind about the TPP? Because I feel like inaction speaks volumes.
No, it's fair criticism, sure. I don't. That's our warrant canary, right?
Your team, are you with us or with the
I wanted to comment on, I forgot, there was a lot that I wanted to comment on, but one thing was the issue that these cross-border data flow provisions could somehow undermine efforts by governments to censor domestically or censor the internet at all. And the thing is that in practice, the free flow of information provisions, which we like to call the cross-border data flows, which is more accurate, would not actually prevent situations like in Malaysia, where right now newspapers are getting taken down And there was sort of the statement from the USTR, was it the White House, that said that, we actually stand for the free flow of information, and we condemn Malaysia's action in shutting down Malaysian Insider. But in practice, the TPP provisions are actually just about foreign services, cross-border services, and so it wouldn't relate to domestic newspapers. And I believe the Malaysian Insider is actually owned by a UK organization, so it wouldn't apply to that either. And that just sort of is a great example of how I think it's very disingenuous to sort of paint these provisions as being like free speech protecting, anti-censorship provisions, but it's actually just a thin veil over provisions that are actually about cross-border data flows that are actually sort of global international tech companies' interests. And so they're not actually in practice going to protect domestic tech companies, or, especially when we're talking about all of these intermediary liability provisions, in which if they had to be liable for all this content, they don't have the money to create a system like Content ID, which Google has probably spent millions of dollars creating to deal with the influx of copyright takedowns. And those safeguards don't exist. And those safeguards don't exist for small tech companies because they weren't at the table. And so it's not even pro-business in the sense that it's pro-business for the entire business ecosystem, let alone especially for, freedom of speech and the entire other ecosystem that is not even business related.
Could I suggest that we pass the mic to Rebecca?
Yeah, definitely. We have 10 minutes. So let's do Rebecca's question. I'm going to do a final round, and I'm taking time on you, and I will let you know when you have 10 seconds left. So please.
Sure, yeah. I just have a question. Obviously, a lot of people who should have been at the table in putting TPP together were not at the table. There are a lot of issues with it. So if it's stopped, or if it isn't stopped, but like looking in the future, how in the future do we achieve trade agreements that don't suck? What's the process? So how should have this been done in order to do it right? And how should trade agreements be put together going forward in a way that really considers all the, human rights implications and the developing world, needs and that are more fair globally? What's the better model?
So actually, the EFF and several other organizations organized a meeting in Brussels, and we came out with a declaration that came out of that meeting, and it was actually addressing that exact question. We had company stakeholders and academics and obviously civil society people talking about, what are some issues that we can agree on, and which was transparency is a major one, and also some sort of acknowledgement of human rights, which is never ever mentioned in these trade agreements, right? To at least have a balance, and so we came out with a declaration that acknowledged these things and had some sort of more concrete suggestions, such as there should be release of text after each round, because if the other country already knows what the country is tabling, there's no reason why it shouldn't be public to everybody else, because the main argument for keeping these trade agreements secret is because it will expose their strategy or their cards in their hand. So and so there's some concrete things that we've decided, and it actually has been cited by Google in a statement that came out recently about transparency in trade. Two former officials from the OSTP have come out with a blog post that also cited this, and so it's at least, the beginning is at least acknowledging that there's a problem, and if the TPP does fail, I think that will just speak volumes for the administration, for the US administration especially, that they just don't have legitimacy if they don't open it, if they aren't letting Congress members even see the text, even let their staff members see the text. So there's some actual concrete steps they can take to make it better. Obviously, it's not going to be perfect, but it will be a step in the right direction.
Okay, perfect. Thank you for that. So the second question over there the first question over there was already addressed by Juan Carlos. We have to do a final round now. We have like 8 minutes. I will take time on you, so please take 1 minute for final remarks. And if somebody wants to take on the second question, is the list of non-compliant measures a way to save national policies from the scope of the TPP? Exceptions, limitations, mandatory licenses. I think that's a very interesting one. Let's go around in order. So 1 minute, please.
Who's just counting? So, Rebecca, one of the things that's very important regarding our question and appears somehow in that declaration is that we need in the U.S. to reform some way the U.S. CHAR works. It's impossible. It's one of the last cooperative agencies, it's one of the last open agencies, it's one of the last transparent agents. They have firm commitments within the open government partnerships, but those commitments are not being really implemented. So if I can say something in 1 minute that's concrete, is that accountability and regarding the U.S. CHAR, because at the end, what Burju said is true. The U.S. CHAR goes to countries not just to validate the laws, they actually go to countries to train with the USPTO, the policymakers that are doing those legislations. So we have some chance, but it still is a balance of power. But we're going to keep working to ensure that the implementation and the signatory goes in the best way possible. I'm from Brazil. I'm very worried with this. TPP language is being reflected on another agreement. That's the TISA, which is a broader agreement that other countries will sign on. So this actually is already in bad terms in the future because we have TTIP, Europe and US, and TISA, global, and the language just goes bad and bad. And the footnotes is actually not a joke. It's very important because if you compare the trade agreements in the last 10 years, the footnotes have increased enormously. So the complexity of the language has increased enormously. So that raises the barrier of entry for new actors. But we need new actors and we need discussion. So.
Thanks. Two quick points. I'm really thrilled to have this discussion. We should have it all day, really. I think there's a lot more we could be discussing. And paying attention to other agreements, RCEP is a very important one as well. It's the Regional Comprehensive Economic Partnership. It involves China, India, Japan, Korea, New Zealand, Australia, and the ASEAN countries. And some of the earlier leaks that we've seen from that agreement have been, in some ways, worse than the TPP on IP. So very important to sort of stay engaged with those countries as they think through new trade rules. I do think transparency is the right path forward. So, you know, the internet is built on the idea that with enough eyes, all bugs are shallow. We should bring that to thinking about how internet-related rules are negotiated in trade. There's no strong reason to have excessive secrecy when we're talking about provisions that affect the internet and 3 billion stakeholders. So, yeah, I think there are actually provisions in TPP that would have been improved as well if there had been greater expert participation, greater transparency around those provisions. Thank you.
So this is a really interesting question because I was in South Africa last week and there was a panel meeting. The UN Secretary General formed a panel, high-level panel on access to medicines, and my background is access to medicines. I'm an access to medicines person. So and in access to medicines world, we already acknowledge that trade agreements are a reality, but there is a policy incoherence and how to establish coherence between trade and health. And now we are facing the same question here: how to establish like coherence, policy coherence between trade and digital rights, or trade and internet. So it is very important that we need to raise awareness. You know, like as Carlos said, like. People talk about privacy, people talk about net neutrality, but those discussions doesn't include any talking points, or even a bullet point, or even like one sentence about trade agreements. And it feels like, you know, okay, trade is there, let's talk what we can talk here, but trade negotiators, they don't live in this bubble. So we need like greater expertise. And most of the time, like I spent the last 5 years of my life going around the TPP countries, talking to the trade negotiators and trying to explain them, trying to provide technical advice and assistance. And those people are trade people. They work for the trade ministries. You know, they don't live in our small like internet or access to medicines or IP world. So they need to hear from us, and that which makes like lobbying, interacting with the policymakers becomes more and more important, because we have to acknowledge that, yes, trade agreements are here, and unfortunately they are not going anywhere. There is no shortage of trade agreements because we have TTIP, TISA, RCEP, like another, like lots of bilaterals. So we have to live with them, but how can we make a difference? Yeah, we're going to kill them. We try to kill them. We'll fight them, but still, you know, we try to make a difference. And in order to make a difference, we need to raise awareness and develop expertise, technical expertise is very, very important, both for negotiations and implementation. And I think then we can push back. You know, that's what happened with the health provisions in the TPP. We push back. And I think there are possibilities, but we really start talking more and more about about trade.
Myra, in a tweet. Come on, wrap it up.
I think many people paint trade as being a complicated issue, and it's not complicated. It's not complicated because it's secret, and a few powerful stakeholders have had a very powerful influence over the text of this agreement. And so at the end of the day, human rights, public interest issues are not going to be upheld when the only sort of mechanisms and the obligations are based upon market interests and economic benefits. That means that free speech gets crushed. That means privacy gets crushed. And especially when none of the safeguards that are in there that the U.S. Trade Representative and other officials point to as saying, oh, these are proper safeguards, they're not actually safeguards. They're just sort of weak platitudes. So, I think we should fix trade agreements, and there are actual practical steps to make them more transparent and better. I think one huge step, and I actually don't think this will ever happen because it flies in the face of trade agreements, is having human rights obligations in these agreements. And that is actually not the same thing. So insofar as trade agreements are just about economic market access issues, it's never going to be a good place to ever decide digital policy.
Thank you, Myra. Anupam?
So the last century we saw liberalization in trade in goods, right? So this century we're going to see, if the countries of the world allow it, trade in services because of the internet. And the only way to make that happen is to allow data to flow across borders, to allow someone sitting in Accra to do a traffic citation database entry in New York City. So that requires global data flows. If we allow countries to do this on their own, countries naturally protect their own people's jobs. That's the government's first instinct. And that's not good for the world at large. I don't think it's a progressive policy. So I think we should embrace trade overall. So if Myra's tweet is trade is not complicated, it's bad for human rights, I would argue trade is good in the sense that it allows people to engage in global economies without having the ability to actually move to that place. We've seen over the last year, what's the most important issue this last year? The fact that we have the biggest refugee crisis in the world. And why? Because people need to be able to move from country to country. Of course, we've seen that that's not, in fact, easily possible. People are risking their lives. The way to engage in economic benefit across the world is to be able to participate in trade, do it from home. And so trade is actually a really good thing. It brings countries like Vietnam or Malaysia, which are part of the TPP, into the global economic order.
Perfect. Thank you. A tweet, because we're already run out of time, so go.
Well, first of all, when I asked the negotiator of intellectual property for Mexico, what the flagship of Mexico was increasing to 100 years after the death of the author, the protections, I actually was expecting a well-reasoned and very complicated, complex argument, and he said, because it's national law. And it's like defending tequila, he said. You remember? You were there.
He did say that.
He was like, really? That's the level of response you're making in public? That's a statement you have in public?
Come on, your tweet. You have 30 seconds.
So yes, the whole point is, even trade is a human rights issue. Trade is a human rights issue because he said it's not. There is human rights here and there is trade here. No, trade is a human rights issue.
Perfect. Juan Carlos.
To summarize pretty much what Carlos already said, but it's true that trade can be beneficial and everything, but trade policy and democracy and transparency should not be mutually exclusive. So we need to get to gain involvement. So there was one question about, well, what are the spaces that civil society has gained? And the truth is that we are pushing for those spaces. We shouldn't have to be pushing for those because it's in the core of democracy to involve the people who are affected in the policies. And this is especially applicable to internet policy. So what we hope is that we can gain more traction into going into these processes and to get involved in them. But we're fighting for that too.
Perfect. Thank you. Pranesh, your tweet.
Trade agreement models that we are following right now are flawed. In every trade agreement, there will be people who get thrown under the bus, but at the same time, trade can be mutually beneficial. When we have a system that is plurilateral, where largely richer countries get together, decide on the rules, and ensure that the rest of the world has to follow it, that's fundamentally flawed, because then the people who are getting thrown under the bus are generally most of the industries and people in developing countries. And the most important internet governance topic that almost no one ever discusses is taxation, including service taxation. Okay, so what is the impact of trade and of free trade in a world where all the main internet companies reside here in the US, right? Those questions don't get discussed nearly as enough as they should.
Definitely. Thank you very much to all our panelists. Please feel free to talk to them afterwards. Thank you very much. Thank you.